We have a representative for the government here. This is case number 230-574-0202. People of the state of Michigan versus Dwayne Whitley. Counsel.
Thanks, Judge. Good afternoon. Steve Benson for the people, case 71917.
Good afternoon, Your Honor. Tyron Rucker, P number 61867. On behalf of Dwayne Whitley Jr., I would ask the court to please excuse my appearance. I was just notified of this 20 minutes ago as I was driving. Thank you.
No problem. Thank you for being able to join us quickly. All right. Are we waiving formal reading and standing your client view?
Your Honor, we are.
Thank you. The court notes formal reading has been waived and enters a not guilty plea on Mr. Whitley's behalf. I'll hear from the people as to bond and then from defense counsel. Please go ahead.
Your Honor, in this matter, the people are going to be asking for a $200,000 cash no surety bond. We're, of course, would be asking for a GPS and home arrest. Your Honor, the people would like to know specifically regarding this defendant, in addition to the matter that the people are just going to cursorily go over, because I'm sure Your Honor has gone over the investigative report. This defendant, Mr. Whitley, is also being charged currently with a carjacking. In addition to that, Your Honor, there will be what appears to be an additional charge on another matter for an armed robbery. So we have this case, we have a charged carjacking as well as what appears to be a pending armed robbery that's in the mix right now. Regarding this particular matter, Judge, and specifically for this defendant, there is a high likelihood of conviction. What we had, Judge, was recognition of this defendant based on crime intel. As well, Judge, we had this entire event captured on green light camera footage. This is a particular incident that I believe was released through multiple media sources. As a result of the release, Judge, there were numerous anonymous tips that were sent to the police department as well as Crime Stoppers with people who had identified the defendant as the individual captured in that footage, Judge. The defendant number 2, Mr. Whitley, in this particular matter, Judge, was the individual, not the one that was wrestling with the police officer regarding the attempt by that defendant to actually take a firearm from a police officer's possession while he was waiting in a gas station. This defendant was postured right next to the police officer when the police officer actually had that firearm taken off of him, had to wrestle that defendant to the ground in an attempt to try to get his firearm. And this is the defendant that had a firearm and was pointing it at the police officer while defendant number 1 and the police officer were wrestling around, and that police officer tried to regain control. Quite honestly, Judge, it's the people's opinion that this defendant's lucky he wasn't shot. Based on the video, based on the statement by the police officer, it's the people's position that that police officer showed great restraint in this matter. Thank goodness that this defendant, nothing happened to him physically. However, Judge, because of what he did, and then subsequently at the end of this incident where this defendant ended up fleeing and was ultimately apprehended based on the community actually chipping in together in an attempt to not only ID him but apprehend him, the people feel justified in asking for the $200,000 cash bond, Judge. He's a clear danger if he allegedly can do this to a police officer, in addition to the charge that we now have learned that this defendant is going to be charged with for carjacking, as well as the additional armed robbery. The people feel justified in asking for that $200,000 cash bond.
Thank you. Defense counsel, Mr. Rucker.
Yeah, Your Honor, first, I'm a little confused. This charge today, my client is being charged with the armed robbery, correct?
The charges against your client today are armed robbery, disarming a police officer, felonious assault, and 3 counts of felony firearm, 1 attached to each of those preceding offenses.
Okay, Your Honor, and the only reason I asked because opposing counsel mentioned carjacking several times, and I was not aware of that at this point. So thank you. Your Honor, I would just say with respect to bond, I'd ask that the court consider perhaps some type of surety that would be allowed. One thing that opposing counsel, I did err in stating is that my clients voluntarily turned themselves in. In fact, it was my office where they surrendered themselves. The parents called me and they were concerned, and they voluntarily, both of them, turned themselves in at my office, at which time I called a member of the Detroit Police Department, and they met, and for their safety, they came to my office and they left without any negative result. So I'd ask the court to consider that.
All right, thank you. To the people, you did mention a separate case that is already ongoing. Have charges already been filed in another case? Or are you expecting charges in another case?
Your Honor, it's my understanding that
Okay,
those charges are going to be coming into the court.
I'm told they were just authorized, actually, including a carjacking and an armed
The
robbery.
fact that there is a case that is being worked on regarding an additional armed robbery.
Okay, all right. So there's a paragraph in the investigator's report that does say that they are suspected. During the course of this investigation, I've received several different calls from citizens outside local agencies, commercial auto theft unit, and other precincts regarding the possible involvement of both defendants and several other carjacking, auto theft, and shooting cases in the city of Detroit and Southfield. So now I'm told that charges have been authorized in another case involving armed robbery and carjacking, that there may be others coming. While I appreciate, counsel, that they turn themselves into your office, you know, it is not lost on me that that turning in occurred 2 days after this is alleged to have occurred, 2 days after it's all over, 2 days after tips are rolling in from multiple sources, and where there may have been a feeling of having no choice but to do so. You know, there's quite a bit of investigation that's gone on here with respect to not only the green light video, not only the facial recognition stuff, but also, you know, associations through other people who know them, etc. The allegations described here are not only extremely dangerous, both, quite frankly, for the officer that was involved, but also to Mr. Whitley, who I agree is very lucky to be with us here today, if what is said is true. And I'm glad he is. But nonetheless, I do think this describes a very brazen act. I think there is absolutely dangerousness to the community. I am going to set a high cash bond for that reason. Bond will be set in the amount of $200,000, cash, no surety. There will be a bond review hearing Tuesday, June the 20th. Okay, that one in front of McConaughey. And then after that, we're going to have June 23rd for probable cause conference and June 30th for preliminary examination in front of Judge Jefferson. Mr. Whitley is not to purchase or possess any firearms or other dangerous weapons during the course of this bond, and is not to have any contact or attempted contact with the complainant in this case, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of the bond. Now, I am told that the other charges were just authorized. I expect that they'll be arraigned on those tomorrow, but if you'd like to hang around for a minute and I'll double check and make sure nothing else is coming through, I'll do that for you. Okay.
Are you talking to me, Judge?
Yes, sir, Mr. Rucker.
Okay.
So I said I'm told the other charges were authorized. I don't know whether or not they're going to ask me to get him arraigned right now, but if you want to hang out in the waiting room for just a moment, I'll bring you back in if they get me another file.
Okay, Your Honor, I appreciate that. Thank you.
Okay. All right. Thank you. I'll put you in the waiting room. Mr. Whitley, please let them know that we are ready for Mr. Henderson to come so that he can meet with counsel. Although I do see there might be someone there. Okay. Thank you so much. I'll put you in the waiting room. All right. Good afternoon. What's your name?
Marlon Henderson.
Okay. This is case number 230-574-0201, People of the State of Michigan versus Marlon Henderson.
Thanks, Judge. Good afternoon. Steve Vincent for the People, P71917.
And Ryan Marad, PA 3665, on behalf of Mr. Marlon Henderson. Waive reading, stamp mute. Mr. Henderson's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Henderson's behalf. I will hear your arguments as to bond.
Thank you, Judge. The people in this matter would be asking for $175,000 cash, no surety. If the defendant were to post, the people would be asking for GPS, tether, and home arrest. Your Honor, the reason why we're asking for $175,000 and not the $200,000 as we did for defendant number 2, Judge. This particular defendant is only being charged with 4 out of the 6 counts in this matter. However, Your Honor, the people would like to note a couple of things before we facially just go over some of the alleged facts in this matter. Judge, this particular defendant was previously on probation for unlawful use of a motor vehicle. In fact, that probation was just terminated only about a month ago in May 8th, 2023. Additionally, Judge, the people feel as though there's very high likelihood of conviction for this particular defendant as well, as he was originally identified through face recognition, subsequently based on a release by the media and tips from the community, Judge. This defendant was identified, as well as the fact that he was picked out in a lineup by the complainant in this matter. In addition to the fact, Judge, there was another individual who ends up having a family member who knows the defendant, who is able to positively ID this defendant. Your Honor, I believe this court is pretty aware of this incident. I believe the community is well aware of this incident, Your Honor. The green light camera footage captured this entire incident. The defendant on the screen today is the individual that actually attempted, not just attempted, but actually gained possession of a police officer's firearm while it was on his waistband, Judge. Subsequent to gaining possession, that police officer was brought down by the defendant in an attempt to try to stop this defendant from fleeing with his gun. They wrestled on the ground. Quite honestly, Judge, just like defendant 2 in this matter, defendant 1 is particularly lucky to be alive. It's the people position that this police officer used great restraint in only wrestling with this individual. And once he gained possession back of the firearm, Judge, this is where defendant 2 ended up pointing a pistol at the police officer. Subsequent to that, both this defendant as well as the other defendant, as captured on green light footage, ended up fleeing the scene, Your Honor, based on all the recognition from multiple witnesses. This defendant was ultimately apprehended. And Your Honor, just like what the people said in the previous matter regarding defendant number 2, this defendant is involved in a carjacking case, which I believe is going to be before this court either today or sometime in the very near future, as well as a potential additional armed robbery, all separate incidents. Your Honor, it's clear this defendant is a danger. If he can do this brazenly do this to a police officer, the people would be inclined to say that he could do this to anyone, and we feel justified in the fact that we're asking for the $175,000 cash with GPS, tether, and home arrest.
Thank you.
Thank you, Your Honor. With regard to Mr. Henderson, Judge, I advise that he's only 17 years old. There's no assaulted criminal history. The court is aware, as the people were aware of the one prior he had, in which he successfully completed the probation. I believe he did his age, that's not on the record, at least I don't see it. But he did advise us, Judge, he's actually enrolled in a step-up program now. So I know that him and his family are taking advantage of some of the he does have some mental health issues, Judge, that he takes medication for. I'm unaware if he's received that. Your Honor, a few things here. The most difficult part about this, Judge, is, these are just for kids. And Mr. Henderson is still a child, really. He's 17 years old. He lives with his mother and his father, and he has a stable residence here in the city of Detroit. It's very easy, Judge, to just give him a high cash bond and keep it moving, but when I look at this individual, I see so many who can benefit from things like house arrest, and has family and ties. And I ask the court to allow him to not be remanded into custody on a high cash bond, because that's ultimately what that's gonna do on behalf of Mr. Henderson, Judge. And I understand the allegations are serious, but I think there can be more stressed out. If this were a sentencing hearing, that would all make sense. But it's not. This is about bond, Judge. I think the complaining witness here, and I'm not making light of the allegations whatsoever, but the complaining witness here was a police officer, not a civilian. So, when we do our danger to the community analysis, I understand the court is,
Well, counsel, we got another file coming in about 5 minutes.
in Your Honor, with the utmost respect, bond is subject to review on a case-by-case basis. I can't. Mr. Henderson's representation, effective representation, would be in jeopardy if that's being used against him without me having anything about it. I don't have a report, I don't have a complaint, I don't have anything. So what I have here, Judge, is this charge of armed robbery, disarming a police officer, and felony firearm. He's not the one charged with felonious assault. So I just asked the court to consider a reasonable bond. I don't think $175,000 cash surety is reasonable. If we want to get his family to put up their house on something and show this on local court, how much, they're willing to stand by Mr. Henderson, in his, in helping him out the legal defense. But I'm asking for a reasonable bond, Your Honor. I don't think that a personal bond with home confinement, on this case alone would be inappropriate. Thank you, Judge.
Thank you, counsel. My comment was only to your statement that this was a police officer and perhaps that had some difference in terms of greater danger to the community. Quite frankly, though, I see it a bit different. I think it makes the act more brazen if it happens as it's alleged here. It tells me that something like house arrest would not really be sufficient if someone is so bold as to attempt to disarm an officer and engage in this kind of behavior. And I get that they're just allegations at this point, but again, there have been multiple tips coming in from multiple members of the community, facial recognition, green light camera, officer identifying him in a lineup. I mean, it doesn't look good. And if what I was really concerned about was flight, then yeah, I'd be worried about his family putting up a house and them trying to make sure he shows up for court. But what I'm worried about is dangerousness, armed robbery, disarming a police officer, and I'm hearing carjacking coming. We'll see. I don't know, but I'm just saying these are the most serious types of offenses. There it is. These are the most serious types of offenses we see short of homicide in terms of dangerousness. And so I do believe a high cash bond is necessary to preserve the safety of the community. I would agree that Mr. Henderson is lucky to be here today. I'm glad he is, despite the stupid decisions that kids make, that teenagers make, that if this is what happened, it didn't cost him his life. But I do believe a high cash bond is necessary to protect the community in this instance. I am going to set the cash bond at $175,000 cash, no surety. If he's able to make the bond, he will be subject to a GPS tether with full home confinement. Mr. Henderson is not to purchase or possess any firearms or other dangerous weapons during the course of this bond, not to have any contact or attempted contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of the bond. As I said, that will be a GPS tether with full home confinement if he's able to make the $175,000 cash bond in this case. Thank you. That being said, I do have the other file. I am prepared to call the case, but I understand if you all would like time to read through the investigator's reports. Would you like me to give you a moment to do so? Thank you. And is there any opposition? Well, let me ask Attorney Rucker. Yeah, he's coming. He's still joining. And these are June 23rd and June 30th in front of Judge Jefferson, if I neglected to say that. Thank you. 23rd and the 30th in front of Judge Jefferson. Looks like that's going to be in both files. What's that one first? Yes. There we go. Thank you. Attorney Rucker, and I need him back in the room. Thank you. One moment, please. All right. I'm still awaiting Attorney Rucker coming back in, so we'll go ahead then and do Mr. Henderson first. All right, so call this one. Where's my case number? Oh, she was doing that. All right. This is case number 235740701. Sorry, 230-574-0701. Nope, sorry, I don't have NITs. 230-574-0702, People versus Marlon Henderson. Okay. Counsel.
Good afternoon, Steve Benson on behalf of the people.
And Ryan Rock, P 3665 on behalf of Mr. Marlon Henderson. Judge, can I get the formal reading here? I don't think he's aware of these charges.
Thank you. All right. Mr. Henderson, we have received a second file for you, sir. This one alleging that you charging you with one count of carjacking, did in the course of committing a larceny of a Ford Mustang, used threat or force or violence against a TJ William Elwert, that being a felony term punishable by a maximum term of imprisonment of life or any term of years. You're also charged, sir, with armed robbery for stealing numerous items from Mr. Elwert, that being a felony with a maximum possible penalty of life or any term of years. You are also charged, sir, with felony firearm, 2 counts of felony firearm, each attached to one of those preceding charges. felony firearm, if convicted, is a 2-year consecutive sentence. However, it is served before you begin serving time on any of the other convictions secured at the same time in terms of its maximum possible penalty. It is a 2-year flat sentence. All right.
Thank you, Judge, and we stand mute to those charges at this time. Mr. Henderson has been advised of his constitutional rights.
Thank you, counsel. Will enter a not guilty plea on Mr. Henderson's behalf, and I will hear arguments as to bond.
Thanks, Judge. The people in this matter are going to be asking for a $250,000 cash no surety bond. If the defendant were to post, we would be asking for GPS tether and home arrest. As Your Honor just previously stated, this defendant in this particular matter is facing 2 potential life felony counts. In the other matter, Your Honor, he was facing 1 count. This is a matter that took place allegedly, Judge, approximately a week before the case that we just went over regarding the robbery of the police officer in the gas station. This, Your Honor, after taking a look at the investigative report, which I'm sure Your Honor has already gone over, allegedly, Judge, this was a situation where this particular defendant, who is alleged to have been in the backseat of a vehicle that pulled into a parking lot where there was already a complainant in his vehicle, pulled next to that vehicle and allegedly used a female driver that was driving the vehicle that the defendant was occupying in an attempt to try to distract the driver of the other vehicle. Allegedly, she had pulled out her phone. The complainant thought that she was just recording. Apparently, this was all a facade, Judge, because Your Honor, once that complainant left the vehicle, this defendant ended up jumping into the complainant's vehicle. There is another defendant, Your Honor, who allegedly ends up pulling out a gun on this complainant. This particular defendant, after defendant number, in this case, Judge, defendant number 2, after he pulls out the gun, this particular defendant drives away in the complainant's vehicle, Judge. I'm not going to get too much into defendant number 2 in this matter, even though he played a significant role, just like defendant 1. However, the people would like to note, Judge, not only was there a gun used in order to obtain the possession of this vehicle, the complainant specifically stated to the police officers that he was in fear of his life. Your Honor, ultimately, what ended up happening was the police ended up matching some of the video that was used in the case that we just went over that occurred, it looks like a week after this. They ended up matching the gun that was used in that particular incident based on the video to defendant number 2's. They put it all together, Judge, and based on identification by the complainants and based on the fact that the defendants were apprehended through voluntarily coming in, we have this defendant here in front of you, Judge, being charged with these counts. The people are feel justified in the fact that this defendant, again, is a danger to the community. Now we have a second instance on top of the previous instance prior to any of these instances where this defendant was in trouble with the law, was on probation, and now we find ourselves here today. He is a danger to the community, Judge. We're not arguing flight risk, we're arguing the fact that he is a danger now to not only what we've gone over with the police officer, but now we're just going over with everyday citizens, and the people feel justified in asking for the $250,000 cash, no surety with a GPS tether and arrest.
Thank you, defense counsel.
Thank you, Your Honor. Again, just to refresh the court with some of Mr. Henderson's ties, Judge, he is only 17 years old. There are no other matters pending against him besides these 2 cases that the court's just arraigned him on. He doesn't have any assaultive criminal history. The vehicle charge he's had, he successfully completed probation. I believe that's off his record. He lives with both of his parents. He's a life resident here in the community. He does have some mental health issues that he takes medication for that he's not received. Now, Your Honor, you know, when I read this report, it's hard to argue that Mr. Henderson is a danger if I'm looking at his alleged actions in this alleged investigative report. The worst of the worst things he does, Your Honor, according to this report, is jump into a passenger seat and allegedly drive away with a car. It's not him who points the gun, it's not him who's found with the gun, it's not him who has the gun. It's not, in both cases, it wasn't, Judge. Now, when I look at what's going on with Mr. Henderson, the court already set a $175,000 bond. He's not gonna get released unless that bond is changed, Your Honor. I'm asking the court for personal bond here, or at least something nominal, or at least something along the lines, less than the bond that was already set. Again, there's no injuries that took place here. My client is not the person that alleged to point a gun at this person, and even in the last case, he wasn't the person who was alleged to point a gun at the officer. He's not. And that's why I believe, Your Honor, with the lack of previous history, with the lack of criminal convictions, that there is a reasonable bond the court can set here that still affords Mr. Henderson an opportunity to fight this case outside of the custody of any juvenile detention center or any jail. I'm going to ask a bond in that nature be fashioned, Judge. Thank you.
All right, thank you. This case is charged as a carjacking and an armed robbery, not a joyriding case. And there's a reason for that. It's not just jumping into a car and driving off. It's alleged that that was done with force, and that force being the production of a gun, and that force being the production of a teal colored gun, which is a detail that now comes into both cases.
Right, but that was from the other defendant, Your Honor.
Understood. But now I have two different occasions on two different days where they're together and a gun is allegedly produced to achieve something like this. And the reason it's so concerning and it's so different than a joyriding case is because when you bring a weapon into a situation where a person is there, there's so much potential for escalation. That's why, that's the difference, right, between a carjacking and a joyriding. It's not a joyriding case. And I don't presume his guilt right now, but I'll tell you, these cameras and recordings are getting better and better, unfortunately, for Mr. Henderson and Mr. Whitley. And it's just, it's concerning. And so again, as I said, if my concern was about flight, we'd be having a different conversation. My concern is about dangerousness here. Again, that concern about dangerousness to the community is going to cause me to impose a high cash bond, which will again give him, of course, a bond review hearing on Tuesday. So I'm going to impose bond in this case in the amount of $175,000 cash, no surety. The next court date will be a bond review hearing, June 20th. That's going to be Tuesday, June the 20th. He'll be in front of Mechanico for bond redetermination hearing. Mechanical will determine whether or not he wants to reduce it or amend it. June 23rd for the probable cause conference again, June 30th for the preliminary examination again, and again in front of Judge Jefferson. All right.
Thank you, Your Honor.
Okay, thank you. Okay, we're still needing to get Attorney Rucker back in here. Does anyone have a number for Attorney Rucker? We'll go ahead and take Mr. Whitley back again, please.
Love you,
Love you,
Marlon.
Mark.
All right, Your Honor, Ms. Henderson, that concludes your son's hearing. All right,
Thank you.
those are his court dates. June 20th, he'll have bond redetermination.
And who was that with?
That's going to be Judge Mechanico on June the 20th.
Okay.
And then after that, his dates are June 23rd and the 30th. June 23rd and 30th in front of Jefferson.
Okay, thank you.
Okay, you're welcome. All right, we're gonna do Mr. Whitley. Oh.
I was talking to Dawn about
Okay, we're back on the case of People versus Dwayne Whitley Jr. One moment, please, as I just take a minute to get some paperwork in order. Okay. All right, thank you for joining us again, Attorney Rucker. We did receive a second file. In this file, would you like me to read the charges?
Is it carjacking? Is it just carjacking, Your Honor?
There's 1 count of carjacking, 1 count of armed robbery, and 2 counts of felony firearm in this file.
Okay. We can
All right.
proceed. I'm gonna put an objection on the record, but okay.
All right, no problem. All right, this is case number 230-574-0701. People of the state of Michigan versus Dwayne Whitley. For the people.
Thanks, Judge. Steve Vincent, P71917.
Thank you. And for the defense.
Tyron Rucker, P number 61867, on behalf of Mr. Dwayne Whitley Jr.
Thank you, counsel. I just advised of the charges on the record. Are you waiving the formal reading?
I am waiving the formal reading, and my client is standing mute at this time for purposes of arraignment. However, I would like to make an objection as to this charge today. I do not believe the prosecutor or the prosecution has adhered to the 5-day hold. I do know the other cases were waived, but I don't believe the procedure is waived. If it's done one time, everything subsequent is waived. So for that matter, I just want to put that objection on the record, Your Honor. We can proceed.
All right, thank you, Mr. Rucker. Court notes formal reading has been waived. We'll enter a not guilty plea on Mr. Whitley's behalf, and your objection is noted for the record. I will hear arguments as to bond for the government.
Thanks, Judge. The people in this matter are going to be asking for a $175,000 cash no surety bond with GPS tether and home arrest. That's the same amount, Your Honor, that defendant one in this case was just given. Your Honor, just to refresh this court's recollection, this is a case regarding the defendant here, as well as the additional defendant and an involved other. The involved other was driving a vehicle to a location where the complainant was already at. Your Honor, the 3 individuals, 2 of which are defendants that are charged in this matter, end up approaching this complainant, specifically the involved other. Apparently, she tries to distract that individual with her cell phone, making him believe that she was recording something. At that time, Judge, that's when defendant 1 ended up jumping into the complainant's vehicle after he had exited that vehicle. Your Honor, upon that defendant getting into the vehicle, it is the defendant in the screen in front of us that ended up holding up a gun to the complainant. At that time, Judge, while the other defendant was in the vehicle, this defendant holding up the gun told the complainant to take off everything, basically meaning take off all of his valuables, which that complainant ended up doing. Your Honor, once he had taken everything off, the female ends up allegedly taking everything. And this defendant, Your Honor, which the people didn't touch on in the other defendant's side of this case, that female, as well as this defendant, get into another vehicle, the vehicle that they were in when they got into the parking lot. Your Honor, come to find out, the vehicle that this defendant drove off in that parking lot was a stolen vehicle as well. So potentially there's going to be additional charges here regarding, and that will be for the charging authorities to figure out. However, as we know it, that vehicle was stolen. The 2, this defendant and that involved other, end up leaving the parking lot. The complainant's car that the other defendant ended up taking leaves the parking lot. Somewhere along the way, Judge, afterwards, this defendant, as well as the other defendant, end up hooking back up. They end up going to a gas station in the complainant's stolen vehicle, and now we have camera footage that has this defendant as well as the other defendant entering that gas station. Your Honor, we also have allegedly the gun that was used in the prior matter that was discussed before this court, identified as the same gun that was used in that incident. Now in this incident as well by the defendant, Mr. Whitley, Judge. Your Honor, it's clear we have a defendant who's a danger to the community. We went over the fact that this defendant allegedly had done what he did to a police officer. Now we have just everyday citizens. We have a complainant in this matter who is in fear for his life and told the investigating officers the same. The people feel justified in this. Your Honor, this isn't about flight. I understand the fact that the defendant ended up turning himself in, albeit now what we're talking about is turning himself in 9 days after this alleged incident. It wasn't the 2 days after the alleged gas station, because this took place 7 days prior to the gas station incident. The people feel justified in asking for the cash bond in this matter.
Thank you. All right, Attorney Rucker, argument as to bond?
Your Honor, again, I would just ask for a surety bond with respect to that. My client is not from a home that has a whole lot of means, so that would be a high bar to do that, given the fact that he has the cash bond on the initial case that was brought earlier before, Your Honor. So again, I would just ask for the second case that if he could place bond on the first one, he'd be given an opportunity to get a surety with respect to this bond, as well as a GPS tether.
All right, thank you, counsel. Out of a concern for community safety, this case involving armed robbery, carjacking, this case involving the pointing and threat allegedly with a firearm described as a teal firearm, so some detail provided which matches up to that other case. I do have, again, grave concern for community safety. I am going to set bond the same as I set it for the co-defendant in this case, which is $175,000 cash, no surety. However, the cases will run together. So they will again be in front of McConaughey on Tuesday, June the 20th, with respect to both bonds. He'll have them both to look at and determine what he wants to do with them at that time. So bond redetermination is set for June 20th in front of McConaughey. After that, June 23rd for probable cause conference, June 30th for preliminary examination, $175,000 cash. You are not to purchase or possess any firearms or other dangerous weapons during the course of this bond. And if you are able to make your bond, you must be fitted with a GPS tether before leaving the jail, which will, before leaving the juvenile facility, which will require that you are on full house arrest, full home confinement during the course of your bond. All right. The court dates June 23rd and 30th are in front of Judge Jefferson, 20th McConaughey. Thank you all.
Thank you.
All right.
Thank you.
You saw, okay. All right. He saw you, Mom.